And mention to sub.
Map result. My lord, I beg to mention item number 22, my lord. 22.
Yes.
This matter may not be taken up because one of your lordships is there, my lord, according its order. So any other day, my lord, along with another writ appeal, my lord. it is-
That order will affect.
My lord,
How that order will affect?
my lord, another case, the leading case, my lord.
Was a case filed by the petitioner and other persons wherein certain directions.
My lord, there is the two different orders, my lord.
Two different orders. Let's the matter come, then only will discuss.
Please, your lordship, lordship, on item number 34, lordship, we require 4 weeks time to file an affidavit in reply or not.
Any objection from the other side?
I've informed the other. No objection, lordship. 34, lord.
4 weeks.
Lordship.
Yes.
Lordships, I'd beg to mention item number 31. With the consent of the other side, I'd like to seek adjournment for the matter for the day. The main arguing counsel is out of town. Your Lordship.
Adjourn.
Please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 40. Lordship, may kindly grant us 3 weeks time to file an affidavit in reply.
Who's for the other side? Have you informed?
Yes, lordship.
Adjourn.
Lordship.
My previous lordship, but with due consent from other side, I beg to mention item number 35, your lordship. Lordship, this matter may kindly be adjourned for a week, your lordship.
Adjourn. Who is for the other side?
I have taken the consent.
am. Adjourn.
Obliged.
Wait, please, your lordship. Lordship, I beg to make a mention of item number 30. I've
Who's
taken
zero?
the. Yes, your lordship.
You are informed?
Yes, your lordship. The counsel is from Nagaland. So I've taken this thing consent through telephone, like she has consented.
Adjourn. Adjourn.
Lordship, I'm praying for 2 months time, because in this matter, government has yet to take up a decision. Some exercises are being carried out, but it has yet to be finalized.
At the request of the concept of the appellant, please this matter for up to 8 weeks.
Obliged.
May I please, your lordship? Actually, with regards to item number 44, lordship, I have instructions to withdraw this case, lordship.
Withdraw.
Lordship.
Wants to withdraw this petition dismissed as withdrawn.
Made to the lordship. May I request the lordship to fix those matter, my lord, that 21st it has come. You fix a date either on Thursday or Tuesday, my lord. Any date as your lordship, because no date is fixed, my lord. Because the matters are very old, 2017, 2018. That's why I'm requesting.
Next week, may it is not next week.
Obliged, my lord.
Daily list for orders, item 1. May I please, your lordship? Lordship, this matter is already admitted, my lord. So the record was called for from the DC North Lakhimpur. That has,
Petition entry.
that has not been received, my lord.
What happened to that record?
My lord,
That record was called for the from the office of the,
the district commissioner North Lakhimpur, my lord.
yes. What happened?
There is a mutation case was done there.
What happened to that record?
That has not been received till now.
Twenty-second of June 2022, there was direction and therefore, thereafter, various directions have been issued and still they have arranged.
My lord, I am for the private respondent, my lord. I am not for
Who is for the government advocate?
Yes, that is the most important.
All government advocate, then only will pass any order. More than a year, they, still they are arranging. It's too much. We are for the appellant.
That's correct.
What's wrong in the order of the Leonard Singleton?
My lord, actually, core issue was the mutation order was passed against the dead person, my lord. On the basis of that, the revenue board has
It
set
was
us.
not the, no, it was not the issue. The issue was that the appellants have filed an application or approached the Board of Revenue
Yes,
that the mutation entry sanction in the year 20 years back, that was wrong.
yes,
And because this person, the respondent has gifted you the land without there being any gift deed produced before the Board of Revenue, only on the basis of the affidavit, the Board of Revenue has allowed your application.
yes, madam. Yes,
How?
our ground was
In the
the,
order of the Leonard single judge, we don't find any infirmity.
my lord, our contention was also that the mutation order was passed against the dead persons and the,
No, this was not the contention. Read Board of Revenue's order. Board of Revenue order is dated page number.
2011,
Page number,
page number 20, madam.
20.
Yes.
Your case was this. Gopal Baru recorded as successor along with Kumari Bahura and her husband late Lakeshwar Barua. This was because Gopal Singh Gohim Barua has gifted his share in the property of Srimati Kori and her husband. These two therefore got the share of Gopal Singh inheritance. Several years later, Gopal Singh sought mutation of his as heir of the late so and so. By the impugned order, the Leonard Survey has granted the same. This is not your case. Not the case that it was sanctioned against the dead person. It is seen from the Barua has filed an affidavit stating that Shri Gopal Singh Barua gifted his share to the property to her husband in the 1962 subseqution on the part of the revenue officer. That is what the contention is. You have simply filed an affidavit that he has gifted us. No gift deed, nothing was on the record.
My lord, that will apart from the record only, my lord.
It is no question of record, sir.
And moreover, my lord, in this case, I am led by senior advocate Mr. D. Das, my lord. He will argue the matter, so let the matter come up any other day, my lord, with the record, my lord.
Pass over for the day only.
Yes, madam.
Pass over for the day.
Who is appearing for the government here? Nobody.
M. Das. GA Assam. Sorry, Mr. Das,
Assam Board of Revenue is there as party. The state of Assam is not
Board of Revenue is a performer party.
here.
N. Das, GA Assam. The last occasion, that is on 29/9/2023, N. Das, learned government advocate. Where is Mr. N. Das? Call him.
State is not even a. But this will be a bit of that. Only the party. Actually, the best is that. Board of Revenue is a party. See, there is an order of personal appearance of the deputy commissioner today. You have to give an explanation. Otherwise, NBW will have to be issued today. Please call it.
Call him. Pass over. Pass over.
Mr. Nath. Have you seen the order last
Yes,
order?
I have taken the order. Well, Mr. Das is coming, I'll take it up after some time. He may have.
That's what is happening. The order of the court.
That's correct.
Yes.
Item number 2.
May it please your lordship. The lordship, as per the order dated 8/6/2023, the lordship has allowed us to implement the respondent number 5 as a party. And
Number 5, notice upon the respondent. number
yes, my
5 is
lord,
not served.
we have served notices, but as per the office note dated 21/2/2024, the service report is still awaited, my lord.
Then produce the service record that the proof that you have served the notices upon the respondent.
Lordship, I have the acknowledgement with me.
He has taken steps.
As per the office report, the notice upon the respondent number 5 is not served. Whereas the concept of the appellant has submitted that the notice upon the respondent number 5 has already been served. She be granted, the concept of the appellant is granted time to furnish the proof before the registry of service upon the of service of notice upon respondent number 5. Office will check and place this matter before this court after a week.
My
of
lord.
registry.
Comes back to the.
How the registry. That will be the testimony.
Item number 3.
May I please your lordship? Lordship, I would like to withdraw this matter as the petitioner no longer wants to pursue the matter.
The concept of the appellant has submitted that petitioner, the appellant does not want to press this appeal, dismissed as not pressed. Consequently, contempt is declared.
You have made this,
PP Gogoi, lordship.
you are there in this case.
Yes,
Are you there in this case?
Yes, lordship.
Your name is not reflected.
His name is Tonin Cosby.
Name is shown. Naam to be.
Item number 4 to 6.
My lord, this is Somoto contempt. Your lordship kindly see the last order. Last order is 19/12/2023.
In terms of that order, my lord, I have filed my affidavit today, my lord. That has not come on record, but I have extra copies, my lord.
In response to this,
Yes, my lord.
Order dated 1912.
1912, my lord, I had placed on record a communication to indicate, my lord, the proposed areas of eviction. So that has been done already, evicted, my lord. To that effect, my lord, I have filed an affidavit today. And I have extra copies also, my lord, and only in respect of one area, my lord.
when it concerns to the Forest Department has submitted that pursuant to the direction given by this court on 19/12/2023 and detailed affidavit with regard to the status after the eviction drive is carried out between 2/1/2024 to 10/1/2024 has already been filed. Office 2 pack the additional affidavit filed on behalf of the Forest Department. Unless this matter after a week.
Item 7. May I please your lordship? Matter may be possible for the timing.
Service complete on respondent number 10 and 16, not complete on 6, 8, 12, 14 and 18. Service of notices on some of the respondents has not been complete, is not complete till date.
I am not.
As per the office report. Service of notice upon the respondent number 6, 8, 12, 14 and 18 is not complete. So stop, learned counsel to the petitioner is granted time to take steps for filing notices for the answered respondents. On filing of the same, let notice be issued to the answered respondents returnable on returnable after 4 weeks. Fresh notice.
Item 8.
Lordship, the petition is admitted already and respondents have entered appearance.
I seek 2 weeks time to file my response. No, item 8.
But then what's wrong in the order of the London single judge?
Lordship, this is a case of overstay.
Yeah,
Overstay on account of the single judge has found that there is an overwriting.
overwriting in the record, yes.
There are 4 documents which the petitioner's husband submitted at the time of joining.
Who has done that?
Lordship, that is what is not been determined. On the basis of which the
Then
single judge
how can
says
you-
that
Then how can you penalize this person without there being any determination? Even you have issued a notice to him for inquiry and later on the notice was withdrawn.
Lordship, because according to our standing orders, we cannot proceed departmentally against a retired employee. So hands are tied.
Then you should have
Lordship-
conducted an inquiry on your own. And come
Lordship,
at least
our hands are
consider-
tied. Our standing order prohibits us from inquiring against a retired.
We don't think. so
employee.
there is any, illegality.
Lordship, there's a Supreme Court judgment in our favor where we are not required to establish mistake or fraud. Lordship,
That is there.
the downside of this,
Which is that judgment?
Lordship, we've quoted it in our petition, page 20.
Page 20.
Lordship, first case is, Lordship, page 20 is what is more relevant.
Chandi Prasad Unyal.
Yes, your Lordship.
Yes.
Lordship, may I read paragraph 13?
Read.
We are not convinced that this court, in various judgments referred to herein before, have laid down any proposition of law that only if the state or its officials establish that there was a misrepresentation of fraud on the part of recipients of excess pay, then only the amount could be recovered. On the other hand, most of the cases referred to herein above turned on peculiar facts and circumstances of the cases, either because of the recipient had retired, or were on the verge of retirement, or were occupying lower posts in the administrative capacity hierarchy. Next paragraph is important. We are concerned with excess payment of public money, which is often described as taxpayers' money, which belongs neither to the officers who have effected overpayment nor to the recipient. We fail to see why the concept of fraud or misrepresentation is being brought in such situations. The question to be asked is whether excess money has been paid or not. Maybe due to bona fide mistake, possibly affecting excess payment of public money by the government officers may be due to various reasons, like negligence, carelessness, collusion, favoritism, etc. Because money in such situation does not belong to the payee or the payer. Situations may also arise where both the payer and the payee are at fault. Then the mistake is mutual. Payments are being effected in many situations without an authority of law, and payments have been received by the recipients also without any authority of law. Any amount paid, received without the authority of law can always be recovered, barring a few exceptions of extreme hardship, but not as a matter of right.
So extreme hardship is there. Now he is, this person is no more.
Lordship,
That is the extreme
Lordship,
hardship.
we
Why
rely,
this- why is
Lordship,
family
we
in
rely
that
that there is a fraud. Under the Contract Act, he knew
by
that he
whom?
was
fraud committed by whom?
by respondent's husband.
That is not determined.
Lordship, no, Lordship, he knew. I can show you to you that he knew. The documents he submitted shows his date of birth in 1956.
For that reason, but extreme hardship case, it's a extreme hardship case.
Lordship,
because
extreme
now the
hardship, they
person
say
no
is
more.
extreme hardship in this case itself, they say it's discovery after 10 years. So somebody's enjoyed the money, you can't recover after 10 years. This is on the verge of this thing. Lordship, look at the other side. Lordship, at some level, we'll be blessing a fraud.
Acha, Ms. Goswami, there are two things. The judgment you have relied upon, that is a case of excess drawal.
Access?
Excess drawal.
Access payment, your Lordship.
Excess
Yes,
payment
yes,
drawal
yes,
is
yes, yes, Lordship. Yeah.
This is a case where this man has got paid his salary for the work he has rendered.
Lordship.
Just a minute. So according to you, he should have retired 1 year back. But he overstayed because there was some entry in his service book which changed the date of retirement. So first of all, this is not a case where he got any amount unduly, but the amount paid to him for
the work
rendered by him. Number one. Number two, if there is an allegation of fraud, then regardless of what is there in your standing orders and instructions, was it not your duty to report the matter to the police? Fraud is a cognizable offense. Without doing so, you unilaterally declare that he is guilty of fraud. He has drawn excess amount of money, and now you want to recover it from the family pension. How do you expect the court to prove?
Lordship, as a public sector, we have to
give back his 1 year that he worked.
No, Lordship, this was not. Lordship, look at the other side of it. Supposing this particular person actually committed a fraud, if we can establish on the basis of judgments that on basis of documents, we'll show your Lordship in this petition. Nothing more than that.
Supposing he has not.
So supposing he has, Lordship, now take my point. Supposing he has, he knew our submission is that he always knew from the day he joined on the basis of documents he has signed and documents he has submitted, school service certificates, that he should have retired in 2016. He knew it. There was an overwriting in the register. Now, all throughout, we rely on the register because the register is what we maintain every day. When the employee has to retire, then we go into and see the underlying documents. When we saw the underlying documents, we saw that no, this 2017 in the register is an overwriting, and every other document reflects it's a 2016. He should have retired a year ago. Now, supposing we accept that he's worked and we pay, at the end of it, what are we doing? We are at the end blessing a fraud. He knew he should not have, he should have reported to us. Non-disclosure is also fraud, Your Lordship. Non-concealment of a fact which you
That
know.
would be even though if he has not disclosed, but the fact remains that he worked for 1 year.
Yes, Your Lordship, he worked.
You can't deny him the wages for that, even though he has overstayed. And without disclosing this fact, he is supposed to be retired on so and so date. Then also, it is not a case
But
of an
Lordship-
ultimately, after initiating an inquiry, you drop that inquiry and there is no determination whether this person has committed fraud or not. That's
And that is how your
my
lordship.
lords have rightly pointed out that it's not a case of excessive payment. It's a case of overstay only. There is no denial that he has not worked that for 1 year, 1 year period. That's a case is
Obliged.
distinguishable.
It's overstay. Our submission is on account of his fraud, and he's the only beneficiary.
That is not.
And as a public
substantiated-
sector,
That is
Lordship,
not substantiated by anything.
Lordship,
he
the
has
documents
committed
that he
the
has
fraud.
submitted,
That he has committed that fraud, that is not substantiated.
Lordship, what happens for us petitioners is that for that period of 1 year, somebody else has been denied. He has worked, but somebody else would have been,
It's not a case of fresh appointment. It's a case of.
yes, Your Lordship, but if he had retired in time, somebody else would have got that post. So 1 year.
Your lordship.
That's a-
There is no infirmity. There is no infirmity in the order. And lordship,
Lordship may hear it, keep it for hearing, we'll. Lordship, may keep it another day, we'll try and persuade you with other case law
Oh, Your Lordship.
and distinguish.
What point?
lordship has already made up
Lordship,
their
that
mind.
at the end of it, there is payment without authority, but Lordship,
And lordship will consider there are two
and
small.
this should not be a precedent,
children.
Your Lordship. Our concern is a public sector, we can't make this a precedent. If this becomes a precedent, then there is a,
This cannot act as a precedent, your lordship. And lordship will consider there are two small children who are waiting for the benefits.
Day after tomorrow?
oblige, Your Lordship, oblige.
But Ms. Goswami, please also address the court on this point. The records were always in your custody. You cannot possibly argue that without the complicity of one of your officials, even a fraud could have been committed, assuming that it was a fraud. So you have to address the court on that point. If you say that none of our employees were involved, yet it was manipulated,
Lordship.
that will be difficult even to hear an argument of this kind. And if there is a complicity, then who is the person responsible? Have you identified that person? Have you taken any action against him?
I'll get instructions,
you-
Lordship.
Can you say that fraud can be established merely on perception of the employer? Fraud is a serious allegation. It has to be determined. You have not even lodged a complaint till today. And that person is dead. You cannot now lodge a complaint.
Yes,
So you do not have any remedy against that person.
we don't even have a departmental inquiry remedy, Your Lordship,
Correct.
so, yeah.
So departmental is not there. When he was alive, no complaint of fraud. Today, you can't initiate civil or criminal action against him. That's the basis of learned civil judges.
Lordship, I'll take instruction and come back.
Please, please.
Yes, Your Lordship.
Look into this.
Yes,
matter.
yes.
Uh,
I follow,
nobody
Your
should
Lordship.
be harassed unnecessarily.
Yes, Your Lordship, I follow, I follow.
Apart from that, you see, he has got paid for the.
Lordship, for
What
work
is-
done, for work done. I understand your lordship, yes. Obliged.
Yeah, Madam.
Item 9.
Service not complete on respondent number
Yes.
1 to 4.
Yes, lordship, 1 and 2 lordship not yet received service report. And 3 and 4 lordship insufficient address return to sender lordship. So I have to take instruction, otherwise lordship, 1 to 4 are legal heirs of late Mohiuddin. They all are brother and sister.
That is required to be. Okay. As per the office report. Notice upon the response, notice of the writ appeal has not been served upon the respondent number 1 to 4. Full stop. Let fresh notice be issued to the respondent number 1 to 4. Requisitions be filed within a period of 1 week on filing of the same. Let notice be issued to the respondent number 1 to 4 by registered post with AD returnable 4 weeks thereafter.
And deeply obliged.
Item number 10.
May I please, madam? Full state of my. I am at 1769, there is delay of 370 days, madam.
When did cost title you were required to file for what?
For respondent number 7 and 5 and 7 is not working in that particular institution, so their name had been dropped.
Where is that amended cost title?
No, that had been in the filing section, it was filed for deleting their name, not before the president. In the CIS, that correction had been made.
The applicant is directed to file an amended cost title within 2
No,
weeks from.
that had been filed, my lord. That in the CIS, it had been corrected, my lord.
You have already filed.
Already filed, my lord. Long back, my lord. Immediately after the order.
24/1/2024, it's an order of 24th of January.
Not sir. It had been filed because it will not be in the court, it will be in the registry for correction that the cost title of in the CIS title, madam.
When you have filed this amended cost title? Because the court has passed the order only on 24th of January. After that, you have filed that order.
Not sir. But that particular date, I don't have it, my lord, right now, my lord.
File amended cost title. It is only listed for that.
So let it come after day after tomorrow, my lord. In the meantime, I will check that date. My lord.
And concept of that. Pays for. And granted a week's time. Applicant to furnish the amended cost title and directed by this court on 24/1. On 24/1/2024. Just after a week.
Not sir.
Obliged.
Item 11.
My lord, the department wishes to withdraw this writ appeal, my lord. Withdraw.
Wants to withdraw this writ appeal, dismissed as withdrawn. Consequently, this IAP wants to withdraw this IA, dismissed as withdrawn. Consequently, the writ appeal number 10530 is also dismissed.
Item 12. But item 12I is for condonation of delay, my lord. We have already served the dusty notice, but the affidavit is required to be filed. We are filing it today, my lord. In item 12.
You are finding that
Dusty, we have already served. The affidavit we are filing today, my lord. We have served the notice on respondent number 1, my lord.
Plant and submitted state. The concept of the applicant is submitted that the dusting notices have already been served upon there.
OP number 1, my lord. Respondent number 1.
And for and in relation to that, affidavit would be filed during the course of the day.
Yes, my lord.
Based on so and so.
Well, item 13, Dusty already served and affidavit we have already filed.
Already filed, but
Yes, my lord.
yes,
169 days delay is there, my lord.
who is appearing for the respondent?
My lord, the other side
Item the thing.
has not appeared, my lord.
Trustee affidavit is filed on behalf of the respondent. On behalf of the applicant stating. Stating that notices upon the respondent number one has duly been served. Full stop. No one is appearing on behalf of the respondent number one. The IA, the present IA is filed with a prayer for condoning the delay of 169 days in filing the connecting appeal. Full stop. Having heard the learned counsel for the petitioner after appellant and applicant, and after going through the contents of the applicant, we deem it appropriate to condone the delay in filing the present appeal. Hence, IA number so and so is allowed. Or registry is directed to register the connected appeal just after 2 weeks.
Lord. Honorable.
Item 14. Application for condonation of delay in filing the writ appeal, my lord.
I file objection.
Sole respondent.
I file objection.
Objection you have filed?
My lord. 22, my lord.
Note the delay and then we'll hear the appeal on merits. Matter comes upon for consideration of the IA number so and so. Under section 5, the limitation act with a prayer to condone the delay of 390 days, 98 days in filing the connected appeal. Stop. Reply to the IA is filed on behalf of the counter to the IA is filed on behalf of the respondents. Having heard the learned counsel of the parties and after going through the contents of the application of IA, we deem it appropriate to condone the delay of 390 days in filing the connected appeal. Hence, the IA number so and so is allowed. The delay of 390 days in filing the present appeal is condoned. The registry is directed to register the connected appeal list after 2 weeks.
Item 15. Well, in item 15, in the condonation petition, we took steps, and my learned friend, he appears for the respondent number 1.
Yes.
There is 169 days delay.
Look, I have no objection, Lordship, your Lordship. Same order. Delay yes. Have you filed any reply? No, Lordship. No counter to the application. You just mentioned it, no counter to the IA is right. Having heard so and so, 169 days delay is control.
Item 16. In item 16, we are required to file the affidavit. We have taken dusty steps, but the affidavit we have not filed. Can you give us week's time?
The applicant prays for and granted a week's time to file affidavit in relation to the justice service upon the respondent. A non-applicant.
Item 17. In item 17, my lord, we have served the dusty notice and also filed the affidavit. Page 19, my lord, affidavit, page 19. He has received the copy, my lord.
What was the controversy?
My lord, same writ appeal, my lord.
Oh,
Same-
compassionate appeal.
Yes, my lord, compassion appeal.
Same order.
Yes, my lord.
Compassionate appeal.
171.
Normally is appealing on behalf of the respondent of desperate service. Yes.
My lord. Habla, my lord. Item 18.
Lordship, in this case, I need some time to prepare the case, Lordship, next week, Lordship.
Need some time to
Prepare the case, Lordship. Prepare.
My lord, in this case, review has been listed after continuation of delay. Notice has not been issued as of now, my lord. So notice has to go.
State is only the party, state is the only party.
State is the only party, my lord.
Delay was 1400, Lordship. Yeah, already completed.
The case of review by,
Sorry, my lord.
what is the ground for review?
My lord, what happened in this matter? The appellant before your lordships, my lord, review applicant before your lordships, he was imposed with a major penalty of removal from service pursuant to an allegation of rape, number 1. Number 2, my lord, engaging a minor in violation of the Child Labor Prohibition Act, my lord. The criminal proceeding was lost simultaneously by way of an FIR, my lord. That criminal proceeding, my lord, culminated to a closure wherein the applicant before your lordships, he was acquitted from the charges. And after that, the petitioner, he submitted an appeal before the authority saying that since I was exonerated or I was acquitted in the criminal charges of the allegation of rape, so my penalty has to be reviewed. Then the appellate authority passed an order saying that fine, so far as rape is concerned, there is nothing, I have got nothing to say. But so far as second charge is concerned, that engaging a minor as a domestic help, that is proof. So removal order is upheld, my lord. So on that count, my lord, the penalty was sustained. In both the proceedings before the writ court as well as the writ appellate court, my lord, what happened that both the courts relied on the report of the medical officer. And that medical officer was never produced in any of the inquiries.
That is a review, what we are asking in review.
I'm
What
sorry.
is the ground for review? That is a merit, that may be a merit of the, your writ appeal or writ petition. What is the ground for review?
Ground for review, my lord, I have stated.
What is the error apparent on the face of the record?
Lord, basically, I am urging on the fact that on the proportionality of punishment, my lord.
That you have already argued before the writ appeal as well as the
No.
writ court.
Proportionality, it was not argued, my lord. Before
Can't be a ground for review, sir.
before the writ appellate court, the proportionality was not argued.
Then what is the error in the order of the writ appeal?
My lord, page 13, I have said the grounds for the appeal review, my lord. Page 13 of the review petition.
Yes, read.
Yes, my lord. A. Page 13A. For that, the Honorable Court was completely misdirected in considering the medical report as relevant evidence in deriving conclusion in the backdrop of the fact that the inquiry officer never examined the medical officer during the course of the hearing. The law is well settled by the Honorable Supreme Court that an evidence becomes a relevant evidence in a departmental proceeding before the inquiry officer to derive conclusion of guilt only when such evidence is proved by the author. However, the instant case, the author of the medical report, i.e. the medical officer, was never examined during the course of the inquiry, depriving the petitioner from his valuable right of cross-examination.
Your ground.
Yes, that was overlooked.
Where is that, how this order of the, this division bench is suffering from error apparent on the face of record?
My lord, the division bench, honorable division bench, my lord, did not take into consideration the fact that the medical officer's report, wherein
Is your argument on merit? Review.
yes. So apart from
Scope of review is very limited, sir.
error apparent on the face of the record is there, my lord. But this,
What error apparent on the point out?
yes, my lord. If your lordships kindly come to the appellate court's order. Lord, basically the writ appellate court did not go into the issue of proportionality at all, because that was one of his
Maybe.
grounds
Maybe.
before the single judge as
That
well as
has not even argued, sir. It has not even argued.
Look, I cannot improve my case at this stage, that's true. But the fact is that, my lord, the writ court as well as
That can't be a ground for review.
writ court as well as the writ appellate court, my lord, ought to have gone into the because lordship will kindly
Without there being any argument.
my lord, pleadings,
Now, there any argument, you have simply argued before that this charge which has been proved is not fully proved and exonerate me from all the charges leveled.
no, what my submission before your lordships is that, my lord, since the trial court has, and trial court, my lord, in the entirety of evidence, considering the entire evidence of the prosecution, came to a conclusion
That
that
standard is altogether different from the decision.
standard is, that's true, my lord, that's both the proceedings, the standard of proof is different. But the fact remains that the conclusion that it was not an honorable acquittal, in my respectful submission, my lord, that was erroneous. Because if
That
your
is
lordship,
erroneous, you have already challenged that in the writ court and thereafter in the writ appeal, and both have been dismissed, then the only remedy available to you is to file challenge that order, that's all.
It's saying it's binding in the DP order,
That is
that he was not honorable.
my submission is that, my lord, he is suffering from malignancy. So I wanted that at least if your lordships considers the petition of the person, because rape was not proved, my lord.
challenge
Yes,
this order.
the rape was not proved, at least he could have asked before your lordships for some leniency with regard to the proportionality of punishment, my lord. Removal from service, my lord, he served the department for 15 years. And removal,
ये आर्गुमेंट नहीं कर सकता क्योंकि उसको कोई एक्विटल नहीं है after 1,000 probably
he served the department for 15 years, my lord. Removal for engaging a minor, because the original charge that was
But sorry, sir, we don't find any case for any ground for review the order. Not there. Because essentially you are challenging the order of the division bench on merits. That is not permissible.
proportionality, my lord, that was not gone into. That is the only ground, my lord, on which I can harp.
Proportionality, you have not even argued, sir.
Sorry, so far as my instruction, it was there in the pleadings, my lord, that's true.
That is, even though if it is in the pleading and if you are not pressing that argument, it is not supposed that the court will consider that argument.
He has not got the honorable acquittal, lordship, in rep case also.
So far acquittal is concerned, my lord, and that was an honorable acquittal, my lord.
This review application is filed seeking review of the judgment dated 24/11/2017 passed by the division bench of this court in writ appeal number 324/2017. Stop. Wide judgment dated 24/11/2017. The division bench of this court has dismissed the writ appeal filed by the appellant, being agreed with the judgment dated 1/6/2017 passed by the learned single judge in WPC number 3055/2011, whereby the punishment imposed in the departmental proceedings against the petitioner, against the review petitioner of removal from service has been upheld. Full stop. Learned counsel for the appellant has submitted that the division bench has not taken into consideration the fact that the punishment imposed upon the review petitioner by the department in the department proceedings is disproportionate to the charges proved. Full stop. It is to be noticed that no such argument was advanced before the division bench at the time of hearing of the writ appeal. Full stop. Otherwise also, having heard the learned counsel for the review petitioner and after going through the material available on record, we are of the view that there is no error apparent on the face of record in the impugned judgment. Full stop. Taking into consideration the fact that the scope of review is very limited, we are of the opinion that there is no force in this review petition. The same is therefore dismissed.
Deeply.
Deeply.
Item 19.
May please your lordship, there's delay of 103 days, my lord.
Notice of IA number 20 returnable of
हाँ सर
4 weeks के बाद कर
Passover meter 1.
Chair, apology, my lords, since in the cause list, GA Assam has not been shown, so I missed it, my lord. Record has been received, my lord. Original record has been received.
already received.
Yes, my lord.
Okay. Mr. Endas, you are Endas.
My lord.
Mr. Endas GA Assam has submitted that the record of the Deputy Commissioner North Lakhimpur.
It's here, my lord. It's there, the original record. Below, my lord.
So Endas, the net government advocate has submitted the report of from the office of the Deputy Commissioner North Lakhimpur has already been received. He has produced the same for perusal. Full stop. List after a week. Then on the prayer of the learned counsel for the appellant. List after a week, as prayed by the counsel for the appellant. Next day, Mr. Das may produce the record, original record before this court.
My lord, in the cause list, GA Assam should be shown, my lord.
List after a week while showing name of GA Assam in the cause list. Reflecting the name of GA Assam in the cause list.
For admission, item 20.
No one is appearing on behalf of the appellant. So it is noticed that on 5/2024 also, none was appearing. None has appeared on behalf of the appellant. In such circumstances, this appeal is dismissed for non-prosecution.
Item 21.
Yeah, please, your lordship. Yes, yeah, please, your lordship. My lord, this is the intra-court appeal, my lord, filed by the, my lord, finance department. My lord, facts in a nutshell is that, my lord, in the year 2010, the state of Assam, my lord, took a decision, my lord, to give notional benefits, my lord, with regard to hike in, my lord, dearness allowance and other applicable components, my lord, and thereby giving, my lord, the benefit to a particular category of pensioners. That action of the state government was SL before the Honorable Single Judge, my lord. Honorable Single Judge, my lord, allowed the writ petition, my lord, following the ratio, my lord, in DS Nakara, where, my lord, the Honorable Apex Court, my lord, categorically held that you cannot categorize the pensioners being a, my lord, homogeneous group, you cannot treat in, my lord, two different ways. Then, my lord, the state filed an appeal before this Honorable Court. In appeal, my lord, it was found that there is another decision of the apex court, my lord, pronounced in, my lord, Amarnath Goel's case, my lord, which permits, my lord, that the state has within its domain, my lord, to fix a cutoff date. And, my lord, being that situation, my lord, this honorable court, my lord, at the writ appellate forum, my lord, find that it may be a good case for review. We went back in review. My lord, the review court held, my lord, that it is not a fit case for review because it will, my lord, require full-length hearing. And as such, my lord, the review petition was dismissed. Against that, my lord, we are again before your lordships. At this stage, my lord, I am praying, my lord, that this matter may be kindly admitted, my lord, because this will require full-length hearing, my lord. Let it be fixed for hearing, my lord. I have served copies, my lord, of the appeal memo, my lord.
Yes.
I appear for the respondent number 123, my lord. The question here is the issue before your lordship is, my lord, the DS Nakaras and my lord, the Amarnath Goel bill. My prayer would be, my lord, your lordship may admit it, but give a short date because many of the persons have already expired.
Having heard the learned counsel of the parties, we deem it appropriate to admit this writ appeal. So, in the meantime, the effect and operation of the order of the learned single judge. Dated.
My lord, the initial order was, my lord.
Admit the parties are already represented and no need to stay. Don't do the stay. There are no need to issue notices to the respondents. List this matter for final hearing in the month of
Last week of March, my lord, if possible.
last week of March.
My lord, may I please your lordship, my lord, with all respect, my lord, there is an interlocutory application whereby I am praying for stay of, my lord, the impunity.
We have not filed any contempt petition, my lord. We
They are not pressing it.
We have not done, my lord. We want to pay it if we decided finally.
I am obliged.
Item 22.
Map freedom. I don't this. No, why not?
Yes. Yes.
My lord, this is the matter, my lord, I mentioned in the morning hours, my lord. The impin order is at page 187, my lord. There the finding was there, my lord. That the page 143, one of the order was not preferred appeal, my lord, for which the honorable single judge did not enter in. That
earlier
appeal we have
petition-
already filed, my lord.
Earlier writ petition was disposed of by the
My lord.
order dated 21/9/2023.
That we have filed appeal, my lord.
What
That was,
happened in that appeal?
my lord, that appeal was not hard, my lord. That's
Not
why I
hard.
made a
Then
mention.
why this second petition?
Second petition, my lord, another notice was issued.
They can't.
My lord, another fresh notice was issued giving
Leonard
20.
Singhal has rightly observed that in the earlier writ petition, there is a specific finding that remains that the petitioners are admittedly encroachers upon Sarkari land and therefore viewed from any angle, they are bound to vacate the land if the same is required.
My
to
lord,
state that
there
law.
is a, my lord, because, my lord, in the instant writ petition, my lord, we have obtained RDI. From the revenue authority, they are saying it is a tribal ban. If it is tribal ban, my lord, there is another PL is going on, my lord.
You go and satisfy the authorities concerned. Simply
My
they have
lord,
issued
may I
a
pray-
notice, a show cause notice to you.
My lord, one note, common notice was issued to
Show
me.
cause notice,
Yes, my lord.
then go and satisfy the authorities.
My lord, may I pray, my lord, one thing, my lord, lordship can be taken up the matter after tomorrow, my lord, along with the another writ appeal, which I have filed, my lord, challenging the original order. my lord.
Can it be, sir? You come, what is the wrong in this order of the learned single judge where he has refused to pass any interim
My lord,
order
my
in your
lord,
favor?
because of the reason, my lord, the last page at page 187, my lord,
Yes,
lordship kindly have a look, my lord, para 10, my lord.
yes.
It is the title to observe that the coordinate bench does not comment upon the direction of the judgment recorded another coordinate bench of the same. As such, the coordinate bench of this court has observed that the petitioner are admittedly encouraged of Sarkari land. Therefore, the view of the angle so and so bound to vacate the land if the same is required by the state. In view of the same, since the order dated operation till date, there is no question of taking view, particularly when the order dated prima facie to be consent order and cannot be altered and modified in this forum. In such the matter, the court is not inclined to pass order because, my lord, there is an already we have filed an appeal, my lord.
What happened in that appeal, sir?
Appeal is, my lord, not yet been heard, my lord.
Then
Lordship
is there
kindly
any
fix.
stay? Is there any stay in your favor in that appeal?
My lord will, my only one thing, my lord, I pray before lordship today, my lord, this matter may be adjourned till after tomorrow, my lord, that appeal be listed.
Why should we list that appeal, sir? There is no question of listing that appeal. That appeal will be decided on its own merit. Whether
My
it is,
lord.
Order passed by the learned single judge or
My lord,
21st
that-
of 25th of September 2023 is suffering from any defect that will be considered in that appeal. Here, what's wrong in the order of the learned single judge where he has refused to pass any interim direction in your favor? Wrong in that.
My lord, only because, my lord, the honorable court hold, my lord,
Yes.
because there is an order. And
Yes,
which,
already there is a specific finding, not
yes,
order,
my lord,
that you are the encroachers. And
Yes,
therefore,
yes.
the court has declined to pass any interim order. What's wrong in that? Until and unless that finding is reversed, suddenly.
my lord,
the learned
that's why,
single
my
judge
lord,
has
I
said,
pray
"Yeah."
before lordship, my lord, this matter may be adjourned. And that matter be decided, my lord, that will has the impact.
That you make a prayer, why this, why should we entertain this appeal?
My lord,
There's
today I
nothing-
don't want to admit, my lord, I want, my lord, only for adjournment, my lord.
Why?
Because, my lord, that appeal has to be decided on its merit.
We don't find any illegality in the order passed by the learned single judge. We are not going to interfere in this. Please. Don't get the matter adjourned for only for sake of your convenience when there is nothing in the order. That's all. We are
Or
not
lordship,
going to
can I
accept the
pray one thing,
petitions.
my lord? I may be permitted to withdraw, my lord, with a liberty to file, my lord, after outcome of that writ appeal.
That you are always free.
My lord, that must be given. my
And
lord.
that consent for the petitioner. The appellant wants to withdraw this appeal with liberty for the appellant to avail appropriate remedy available to him
My lord.
under the law after disposal of the appeal.
Writ appeal number 12, my lord.
Writ appeal number
12 of 24.
12 of 24. Dismissed with liberty as prayed for.
Lordship.
Item 23. This present rate appeal has now become infructuous.
Infructuous.
He was a Gaon Panchayat president in the meantime.
Dismissed as infructuous. You are what?
AMS, the appellant.
So you are also
Infructuous.
dismissed. The parties are in agreement that this writ appeal has become dismissed as infructuous.
Item 24.
Made, please, Lordship. Well, the challenge that I made before the learned single judge was a notice issued under section 4 of the Public Premises Unauthorized Eviction Act 1971. My lord, that was a central act. Now, my lord, the land in which we are under our occupation, my lord, belong to the state government. The revenue record also says that it belongs to the government of Assam. Now, my lord, the railway authority has no, railway authority, state officer has no authority to issue notice under the central act. There is a state act also, which says, my lord,
What notice they have issued?
they have issued notice to show cause and vacate, because since they have got
Where is that notice?
notice, my lord. In fact, what happened in 1999?
Where is that notice?
Notice, my lord, you can find as 100, page 100.
100.
Yes. They have not given any details of the fresh notice issue.
Yes. Where I am authorized to have an opinion on the ground specifically where unauthorized occupation so and so grounds railway now. Pursuant to the action should not be made. In pursuant to the laws of I call upon to appear before the really authorized activity. All material persons. So what is this notice says?
My lord.
Show cause notice.
Show cause. My lord will kindly come to page
And in
75.
pursuant to clause B, so and so. Also call upon you to appear before me in person or through
That's
a
right.
duly authorized representative capable of all the answers, all material questions connected with the matter along with the evidence you intend to prove in support of cause shown. That's all.
My lord.
So the notice is issued to you that the railway is of the belief that you are in unauthorized occupation of the lands of the railways. Now, if your case is that this land doesn't belong to railway, go and show it to the
Well,
railway
it happened
authorities
like that.
this land doesn't belong to you. You have no authority to issue that this notice. They quash this notice or drop
Lordship
the
is
proceeding.
absolutely right. Lordship is absolutely right. What happened, my lord? In 2009, they have issued similar notice where we submitted all replies, each and everybody. Now, then they did not proceed further. Thereafter, my lord, the government of Assam has taken up the, my lord, for settlement of all land. This land, the government of Assam, Lordship will kindly have a look at page 75, my lord.
Mr. Consul, what we are saying.
No, Lordship is right, my lord.
All these material which is available to you, to the authority concerned who has issued the notice, is bound to consider that.
But, my lord, they, in our street petition, we have said, they have started demolishing, my lord. After
Have you filed any response to this notice?
Yes, my lord. In fact, your lordship, in next page, one of us, your lordship, this is notice is issued to one, the second stage.
Yes.
They have submitted a reply, my lord. That since they, after the reply.
Only one person.
One person. That's why, my lord.
Issued only to one person.
One person.
And how many appellants are here?
Appellants are many. Now, my lord, it happened like that. No, my lord, it happened like that.
Cause of action arise to you when no notice is issued to you?
No, it happened like that, my lord. All the petitioners were issued notice earlier. In 2009, the lordship will kindly have stated.
Fine.
Then we have submitted a reply and saying that you have no jurisdiction.
Fine.
Because land belongs to the government of Assam. A revenue record also says the land belonged to, they have in their affidavit in our opposition also said the land belonged to the government of Assam. That doesn't say. They only say that it is reserved for railways. So, my lord, in order to have jurisdiction to, my lord, issue notice, they must have, my lord, the land must be belong to the central government. We have issued, lordship is right, my lord.
Okay, that's why only we are simply saying, go and show it to the person. First of all, though, out of only, how many appellants are there?
Now, my lord, since after the
Out of
execution, many
29
died.
Out of 29 appellants, notice is issued only to the one appellant.
One, others who
And,
did not come.
And the except one, the other persons have approached this court in apprehension. that
Lordship.
They may, the authority may also issue notice to them, which has not been issued to them till date. And even if this appellant number, one of the appellant to whom the notice has been issued, he is free to go there and show cause that this land doesn't belong to you. You don't have any jurisdiction. If he passes any order adverse to you, you have authority to, you have liberty to file an appeal against them. Why this writ court should go into all
My humble,
this?
my,
Not supposed to
on
go.
that one, my humble submission before lordship is that if I go there, your lordship will be giving them a jurisdiction, my lord, because that doesn't have.
No, not at all.
Section
Not at
4,
all. Simply in response to the show cause notice, you show your material or whatever your case is that, Mister, you have no authority to issue such notice. We'll consider it in accordance with law. If an order goes against you, file an appeal. Why this writ court
No, my lord.
entertain all such?
No, my lord, if your
When
lordship,
there is a mechanism already there, why should we interfere?
no, lordship is right, but my lord, in what our apprehension is, since one of our neighbors have been, my lord, dismantled, that's
The
why. my
basis
lord.
of apprehensions, writ petitions can't be maintained. Sir. Sorry.
And my lord, in fact, the, no, lordship,
It's
Nothing was possible.
yes.
my lord, if any notice is to be issued, it should be issued by the authorities of the government of Assam. They did not. They have tried to, my lord, settle the land. That's why, my lord.
Concept here again reiterating. If that is the position, go and show they show this to the authority concerned of the railway that you have no authority to issue this notice. That's all. He'll
Then-
consider it in accordance with law.
Then my prayer would be, my lord,
Yes.
my lord, prayer would be, I'll go before them. At least they without,
Except one person, why you go before them?
no, my lord, as and when notice would be issued, we'll go. No, my lord, and in fact, that person already went there. Pursuant to the order passed. So, my lord, my prayer before lordship is, in the event notice is issued, they will not disturb me till the notice decided.
We are not going to, please.
Because
We are not entertaining the writ petition and granting an interim order. That is not at all permissible.
my lord, at least the one person who already filed a reply pursuant to the order,
Then
let that
in case-
petitioner, he may
the
not be
authority
disturbed.
is bound to consider his reply and thereafter to pass order in accordance with law. If the order is illegal or if you are aggrieved by that order, that person He can approach the appellate authority by filing appropriate.
That's right, bro.
appeal,
I
that's
can.
all.
No, my submission was only,
This appeal in the writ petition and learned single judge has rightly declined.
no, but the direct Singh did not go into all this, my lord, that whether the jurisdiction or not, because of the central act, it is issued under central act.
The learned single
there
judge
is
is of the opinion that only one person is issued, notice is issued to only one person. And no notice till date is issued to any other person, therefore no cause of action arises.
No.
And that person, 15 days time was granted to that person to file reply before.
He submitted reply raising the question of
Whether he
jurisdiction.
has decided that proceedings finally. The authority has decided those proceedings.
No, no, my lord, no, they did not do anything. They did not do anything. Right from 1999, only, my lord, a few of our neighbors have been, my lord, houses of few of our neighbors have been dismantled. That's why, my lord.
Now, what do you want?
My lord,
What do you want in this appeal? Either on merit, order on merits, or what do you want?
no, my lord. No,
In this appeal, you want order on merit or what?
no, they, I can draw, my lord, my lord, with liberty, my lord, to
Liberty of what?
avail the
The notice has not been issued to all the appellants except one. What liberty
My
you are
lord,
seeking?
one
You
can.
are inviting that issue notice when that
My lord,
will issue a direction to the railway authorities, issue all of them a notice.
My lord, I sought for preventive justice, my lord, because I can also come, my lord, on apprehension.
Apprehension may not on in every case. And when the apprehension is not strong enough, certainly not.
Then, lordship, I withdraw it. And lordship allow me to withdraw as being
After
premature.
attempting to argue the matter for quite some time, learned counsel for the appellant wants to, has submitted our instructions that he wants to withdraw this writ appeal. However, seeks liberty that in case any notice is issued to them by the railway authorities, they may respond to the said notice, and they may respond to the said notice. Dismiss with liberty as prayed for.
Obliged to.
Item 25.
I know.
The learned counsel, the appellant has submitted that the learned single judge has grossly erred in ordering, grossly erred in directing the appellants to pay interest at the rate of 7.5% on the whole value deposits made in respect of e-auction dated 12/3/2013 and 28/6/2013 from the date of deposits till the date of refund. Learned counsel has submitted that there is no provision under the agreement executed between the parties regarding payment of interest on the regarding payment of interest on the deposits. Full stop. Admit, issue notice, returnable on so and so. Notices be sent through registered post with AD to the respondents, returnable on 6 weeks ke baad ki date is na. In the meantime, the direction issued by the learned single judge of making payment to the respondent at the rate of 7.5% per annum on coal value deposits shall remain stayed.
Item 26.
Major lordship, we pass over for time being. Pass over.
May it be your lordship. Lordship, no copy has been served to the Fishery Council.
That I am not aware. The council just informed me. Just pass over for time being.
Also for the time.
Item 27.
Sami answer this you B, na?
Notice, returnable on so and so.
My lord, there was an interim order before the single judge that one post is to be kept vacant.
The selection is of the year
2018, my lord.
2018.
Yes. Till the impugned judgment, my lord, that interim order was there. In the IA, we have annexed that order, my lord.
Yeah, it is there.
Yes, yes. Page 8, my lord.
8.
And operative portion is at page 11. Para 8. In the interim, as learned senior counsel for the petitioner has been able to prima facie satisfy the court that answer key given by the petitioner would not be incorrect. It is provided that in the interregnum, that respondent 2 to 5 shall keep one post of sub-inspector.
Yes,
As
Mr. Counsel.
Lordship, my senior is on legs, Lordship. My senior is on legs, Lordship.
Already appearing.
Lordship.
Don't make these submissions in court number 1.
Okay, apology.
Inform your counsel that you have issued the notices and issue notice. Mr. Appearing on behalf of all the respondents.
Lordship, on behalf of Dibrugarh University, Lord.
On behalf of
Dibrugarh University.
Question paper.
6 and 7.
I'm appearing for respondent number 1 to 5. 1 to 5 you are appearing and respondent number 6 and 7 you are appearing.
Lordship.
Issue notice. Mr. So and so is appearing on behalf of the respondent number 1 to 5. Mr. So and so put in appearance on behalf of the respondent number 6 and 7. Service is therefore complete. Concept of the respondents raised for and granted time to complete their instructions. In the meantime, one post of sub-inspector in bracket unarmed branch bracket close as advertised by notice dated 11/4/2018 be kept vacant till next date.
Deep. Oblique dot.
Item 28.
May please, your lordship. My lord, in this case, my lord, by order dated
If both of you are willing to submit the dispute to arbitration,
My lord.
you see, we have a panel of arbitrators,
My lord.
as you know. So if you can agree on a name, why don't you file a joint affidavit? We'll close the matter by sending it directly to arbitrator.
My lord, can I take a standing instruction from the department, my lord? Thank you for that.
You also
I
agree?
will have to take instruction, at least 1 week time may be granted, then definitely.
Both of you agree that will save time for both of you.
Learned counsel for the appellant as well as the respondent seek some time to complete their inspections. That why not, the matter may not be referred for arbitration. Learned counsel for the appellant as well as the respondent takes some time to complete their inspections, that why the matter may not be referred to the sole arbitrator for adjudication of dispute regarding payment between the parties.
All right.
List one.
Much obliged.
Item 32 and 33.
Lordship, this is an appeal filed by the Assam Fisheries Development Corporation, Lordship, against the order dated 27/6/2022 passed by the learned single judge, Lordship. Lordship, in this matter, as directed by your Lordship, we have already filed our additional affidavit also. And by virtue of order dated 27/2023, interim order is operating, Lordship.
They have already filed additional affidavit.
Lord, the issue is very simple. My lord, through 4 different channels, persons were recruited into Assam Fisheries Development Corporation, which is a government of Assam undertaking. Now, their contention is that all the 4 channels through which the people have entered into their services, those were done without any advertisement. But so far the petitioners are concerned, there is not even a remote allegations that they have adopted some unfair means to get into their service. Now, only thing is
You
that
have not adopted, but here they found that one Naren Chandra Basumatre, ACS secretary, was indulged in irregularities in regularizing the employees of Assam Fisheries during his stint as manager director AFDSL with the department. Proceedings has already been initiated and he was placed under suspension.
but they have also lost a criminal proceeding against some of the erring officials. Some of them has obtained a stay order from this honorable court and some of them have already been taken pre-arrest as bill. That is another process matter. Please number. My lord, so far we are concerned. We are concerned now only with the salary which is due to us before the completion of the inquiry report. Because you have extended our service, your lordship will find that order at page 31. Only these people who are now without job will get this pay for those period that they have rendered their services.
Whether these people are still continuing?
No, after the, this is prior to, this salary is also prior to, your lordship will find from the order date, page 31.
They were engaged in 2020 and 21
Yes.
and discontinued from service in
Lordship, may kindly see page 63 of the
22. Exact date before.
one appointment order is there, Lordship. Lordship will see there.
Since October 2022, they are without, their services have been terminated.
Page 63.
That those terminations are now under challenge in a different writ petition that is not before your lordship. We are not concerned with now with the outcome. Now is that this order at page 30 is only in regard to the salary that which they will get for 7-8 months for which they have rendered their services.
63, what you are pointed out?
Lordship, may kindly see second line, Lordship. This order was issued.
In the interest of the public service and pursuant to the direction of the board,
No such order was there, Lord.
followed by the order
Yes.
issued by the
In fact, Lordship,
Honorable
no,
Chief Minister, and considering the vast experience honoring the order passed by Honorable Guwahati Court.
yes, Lord. No such order was there. The illegality starts from there, Lordship. In fact, no advertisement was there. No post was there. No interview was there, Lord. And Lordship, in the meantime, all the actions has been initiated against all the officials, Lordship, and including MDs, Lordship.
Matter requires consideration, sir. We'll consider.
My lord, your lordship will see even the inquiry report at page 124. Not a single allegation against these petitioners that they have adopted any illegal method to get. They are all.
You are the beneficiary.
Yes, my lord.
Even
We are
though
the
if official
beneficiaries.
has committed some irregularity.
My lord,
You are the beneficiary.
Yes, my lord. But we were persons, we were walking, some of us are walking near that fishery. So we have been walking, they said that we'll regularize your service. There is no monetary transaction to show that we have paid money to.
That is the matter of inquiry, sir.
No, in the inquiry report, they have not pointed out any single allegation against me. That's why we have challenged.
That page 63, Lordship, the person himself, petitioner number 1, Lordship. He himself signed his own appointment letter, Lord. That is what I'm submitting from page 63. On behalf of the managing director, Lordship, he himself signed his appointment letter.
No, this is not.
Let us speak.
This.
Having heard the limited concept of the parties, we are of the view that matter requires consideration. Hence, admit no need to issue notices. Parties are already represented. The interim order passed by this court, wide order dated 19/5/2023, is made absolute till final disposal of the appeal. Stop. Now this contempt case, in view of the stay order.
Lordship, may kindly see order dated 16/3, Lordship. Yes, one undertaking has already been given that the contempt matter will not be proceeded with, Lordship.
No, but now since the order is already, the order complained of is already stayed.
Yes.
My lord,
remains in this.
my lord, leaving aside this, all this paraphernalia and all, only today I am praying that your lordship will hear this matter at the earliest, because either way, we get the 6-month salary, we get the 8-month salary, or otherwise no use.
Hearing in July 2024. In view of the fact that in view of the interim order passed by this court, which has been made absolute today, the contempt case number 413/2023 is disposed of.
My lord, I only pray for an early July is, my lord, after
June.
Well, normally we don't bargain with the date when an honorable Chief Justice
Then why
says.
are bargaining?
Well, let it be May, my
No
lord.
kind of you, sir. Thank you.
May, lord. My lord, may I pray for a fixed date on June, my lord, from the court master?
Any fixed date?
Yes,
of-
yes.
convenience of Mr. Consul.
Item 26.
Wait, please, your lordship, my lord, in this PIL, my lord, I filed a reply of the affidavit filed by the respondent number 1, 2, and 4, my lord. Though, my lord, I filed it on 20, my lord, today it is processed, my lord. So,
What material you have placed on record the illegal allotment were? What material
my
you
lord,
placed on record?
my PIL is based on the complaint filed before the deputy commissioner, my lord.
That complaint would be dealt with by the authorities concerned.
My lord,
This court is concerned with that.
my lord, though deputy commissioner has taken steps, my lord, by directing the executive officer of the Dovaka Municipal Board, my lord, page 22, my lord.
Yes.
Nothing has been done, my lord. So, my lord,
Sir, approach the authorities concerned or the higher authorities. Why this
Well,
court should interfere in this?
my lord,
You
deputy
have already
commissioner,
filed complaint, the complaint is was proceeded. And now if on any complaint, that complaint, and even if you are claiming that some fraud or irregularity is there,
yes, corruption, my lord.
corruption, then file complaint, criminal complaint, sir.
My lord, we have filed complaint before the deputy commissioner. He is the controlling authority as per act also, my lord.
Also approach the court concerned.
Lordship.
If there is any this commission of cognizable offense, go and file a complaint with the police. It's, what is the material ultimately
And,
simply-
this-
where is your complaint?
My lordship, may kindly see page 17, lordship.
Page 17.
Yes, lordship.
It is hereby informed that since few days, the Dovaka Municipal first position entire district were committing corruption as a result of public petty business being made. About the corruption, market petty businessmen, local express their opinion heard. Their opinion heard in this regard, public are raising their finger, act of admission because the Dovaka appointed one executive of the one of few example mentioned in the mills. 34 numbers of small rooms constructed under modern market. The municipal board collected 50,000 AC from the unknown person through bank transfer. Thereafter, rumors spread mouth over against the public petty businessmen. Locally, they sold each, 3 lakh to 4,000. In the market, people encroach on the land, they are opening shop. The government money is wasted in the name of Swachh Bharat. Money. These are the bald allegations.
Lordship,
On the basis of
I have
that,
annexed.
We issue a writ of direction, writ of mandamus.
This also published in
These
the
are the
newspaper,
allegations.
madam.
These are, you have heard in the public that some money was exchanged. How
Well,
this allotment was illegal?
Also
Individual
published,
persons who have been allotted, you have made them party.
my lord,
Have you made them party in the
my lord,
petition?
I am
No,
seeking,
my
my
lord, I
lord,
have taken
inquiry.
the
My lord,
specific plea
my
affidavit.
specific prayer is for the inquiry by the deputy commissioner, man.
That you may approach the authorities concerned, how this PIL is maintained.
And my lord,
On this,
interestingly, my lord, this honorable
Based
court
on bald
also,
allegations, vague allegations. You have heard in the market that money was transferred for the purpose of allotment of shop.
my lord,
To whom money was transferred, who the persons who gave the money, who the persons who deprived from the allotment,
madam.
though they were more eligible persons. Where is that?
Oh, my lord, this is also published in the local newspaper, my lord. This and all,
Newspaper, there are so many things are published. On the basis of this,
and my lord, that's why, my lord, we approach the deputy commissioner as per act, my lord, he is the controlling authority, my lord. And my lord, this court also instructed the deputy commissioner, my lord, instruction, my lord. Interestingly, my lord, deputy commissioner remains silent, my lord. And respondent number 1 and 2 and 4 filed an affidavit, my lord, stating,
earlier you have filed the petition before the learned single judge.
yes, my lord.
Then
That was done with liberty, my lord, because,
liberty to file fresh.
yes, lord,
So you have filed fresh PIL.
yes, lord.
How can it be, sir?
Because, my lord, the prayer was the same, my lord, and
It was the same. How this is a public interest petition, sir?
my lord.
We are not.
So, my lord, Deputy Commissioner,
To move appropriate application before the concerned authority regarding that. We are not entertaining this.
my lord, we have submitted the complaint, my lord, that
Then became,
before director also, my lord.
yes. This writ petition is filed by the petitioner in the design of public interest petition, essentially with the prayer to issue direction to issue a direction, essentially with a prayer for declaring that the action of the respondents of allotment of shops in the modern market as well as the vendor market in the Duboka Municipal Board
Therefore declaring that the action of the respondent of allotment of stocks, the northern market as well as the market, the program municipal board
as illegal. Full stop. It is also prayed that necessary order be passed for conducting an inquiry into the irregularities committed in allotment of the above referred shops. Full stop. Having heard the learned counsel for the petitioner after taking note of the fact that on a complaint filed by some persons, including you are also the complainant,
Yes, some of-
including the petitioner, the deputy commissioner, who has passed the order for inquiry.
My lord, Deputy Commissioner directed to the executive officer, my lord, of the municipal board.
Commissioner concerned has already issued a direction to the executive officer to inquire into the matter. Full stop. Then it concept for the petitioner has submitted that despite the direction issued by the deputy director concerned, the executive officer is not is not conducting any inquiry in the irregular allotment of the shops in question. Full stop. It is also contended by the learned counsel for the plan, for the petitioner that corruption took place in allotment of the shops. Full stop. Having heard the learned counsel for the petitioner and after going through the contents of the writ petition, we are of the view that vague allegations of corruption in allotment of the shop has been leveled by the petitioner in this petition. No details regarding the illegalities and irregularities has been provided by the petitioner in this petition. Stop. On the basis of these vague allegations, no writ of mandamus can be issued as prayed for by the petitioner. Full stop. It is to be noticed that the petitioner has already filed a complaint with the concerned officer, and the said officer has already ordered for inquiring into the complaints. And therefore also there is no reason for us to interfere in this writ petition. If the inquiry is not conducted by the concerned officer, it is always open for the petitioners to approach the higher authorities for seeking reliefs. In view of the above discussion, we don't find any merit in this writ petition. The same is therefore dismissed.
My lord, I would like to point out one thing, my lord.
The deputy commissioner my lord, requested the executive officer of municipal board taken as per the, my lord, order dated 27/23. Immediately the petitioner filed this PIL. Then my lord, the executive officer filed the affidavit in opposition.
Already dismissed the petition. Petitioner.
It has to have good.
Published.
Item 37.
The three issues, my lord, those have arisen for consideration, my lord. Whether my lord, the notification under section 6 issued by the central government.
So the pursuant to that, this order passed by the learned single judge. The proceedings of issuance of notice and hearing of objections have already been completed. Then
land has acquired,
your lordship. Land has also acquired. Then what?
Land has been handed over. My lord, now the question, my lord, that remains, my lord. While the act says, my lord, provides a date, particular date for completion of the my lord, the compensation. Whether, my lord, the honorable single judge was justified in fixing a different date, my lord.
Where is that?
That is one aspect, my lord. My lord, the section 10 of the act, my lord, provides that the competition will be from the, my lord, prior to the date of the, my lord, notification under section 3 of the, my lord, act. Now, honorable single judge has, my lord, taken a view, since the notice issued pursuant to the, my lord, the subsequent to the, my lord, notification was received by him only on 1/7/2022. So therefore, the, my lord, that will be the date for, my lord, computation, my lord. That is one aspect of the matter, my lord. Secondly, my lord,
Where is that portion which you are relying on?
lordship.
Para 15.
Page 287.
Read.
Paragraph 15, it would appear from the record and from a perusal of the writ petition itself that the petitioner has notice of the said acquisition proceeding on the date on which he received the communication dated 26/2020, which he claims to have received on 1/7/2020. It further appears that paragraph 6 of reply dated 3/7/2020, he had stated that he had made construction of 10 years before and he have not constructed any illegal structure over the land. Now, lordship may come to the next page, my lord, page 288.
Yes.
The last paragraph, my lord.
The above direction is being passed taking into account peculiar facts and circumstances of the case, and the instant order shall not affect the other acquisition carried out in respect of Dock number 255 of Patta number 17 of village Radhakusi Kamrup made by the respondent authorities under the Act of 1962. As the petitioner had notice of the acquisition proceeding with effect from 1/7/2020, the petitioner shall not claim any equity on any construction made pursuant thereto. Okay. My lord will find, my lord, firstly, my lord, the finding of the, my lord, whether, my lord, the finding of the honorable single judge with regard to my lord, serving of the notice on the writ petitioner is correct, my lord. My lord, the observation.
Single judge notice will be deemed to have been served today for conducting the hearing in the matter, which is already, that is the idea, not for determining the date of compensation.
There is no. That's right, my lord. As the petitioner had notice of the acquisition proceeding with effect from amendment, the petitioner shall not claim any equity on any construction made pursuant thereto. So, my lord, till 1/7/2020, he will be entitled to the compensation, my lord.
Really, what's wrong in that?
Because, my lord, the act provides, my lord, that the compensation will be, my lord, prior to the date of, my lord, notification issued under section 3 of the act. That is one thing, my lord. Well, I'll come to that. My lord, the honorable single judge, while holding that the, my lord, the writ petitioner was not served, my lord, has, my lord, relied on the, my lord, annexure, my lord, 5 series and the 6 series.
So you just tell me one thing.
Lord,
The proceedings which the learned single judge is allowed to continue, that has been concluded.
My lord,
Section 3 notice, public hearing and acquisition.
Lordship, my lord.
And compensation has also
No,
been
no,
paid.
that has not been paid, my lord.
What is that part compensation has been paid, your lordship?
That is
In
pursuant to
part-
the direction of the, my lord, honorable apex court, my lord, because we had, my lord, gone against an order, my lord, whereby the honorable single judge in a different proceeding, my lord, those are also pending, my lord.
Hearing was conducted, your lord.
Without being influenced by any. Everything.
The date of notification is section 3 notification,
But it was on 16/10/2018.
16/10/2018.
18.
He said we make construction saying that.
That was not served on me.
ज्यादा बोल दिया
My lord, I am also assailing the finding of the honorable single judge with regard to, my lord, holding that the notice was not served on the, my lord, writ petitioner.
That part is over.
No,
That
my
part
lord,
is over because now you have provided an hearing. After hearing, you have already concluded those proceedings, then that the part is over.
lordship, my lord,
Land has been acquired. Then
land
that
has,
part
my
is-
lord,
Now,
pursuant,
so far as regarding compensation is concerned,
lordship, my lord.
we can do one thing. We'll observe one thing that the compensation will be awarded to the petitioner as per the provisions of the act without being influenced by any observation made by the learned single judge in the impugned order.
Lordship.
Yes,
No.
Mr.
Lordship, one aspect, your lordship, so far as that date is concerned, your lordship will kindly find that section 3(1) notice was issued on 25/1/2019, your lordship. Now, if your lordship comes to the judgment of the honorable single judge at page 284, para 11,
Yes.
finding regarding the notice, your lordship.
Yes.
Ultimately, your lordship, notice you will have to be served on me, your lordship, so that I get an opportunity.
That's another thing, sir. What they are saying, that whatever the determination of the compensation would be relevant on the date when the notification under section 3 was issued. This is what the law says.
Lordship, at the same time, your lordship, unless your lordship, that notice is served on me, your lordship, that at no point of time that.
That's why only as per the law, this Petroleum and Mineral Pipeline Act 1962, the compensation will be considered as per the provisions of the act.
There is one problem with that, your lordship. Problem is that pursuant to that, your lordship, during pendency of the proceeding before the honorable single judge, some award was passed, your lordship, by the competent authority. Now, your lordship, that your lordship, when this award was passed, your lordship, then subsequently they tried to review that award, your lordship, saying that this was an interim arrangement we have made. And that award, your lordship, we have put to challenge, that subsequent order of review we have put to challenge. That is pending before the honorable single judge, your lordship. Now, your lordship will kindly see, once the award is already passed, now, your lordship, it will amount to again, your lordship, review of the award, your lordship.
You can simply say the compensation should be paid as per the provisions of the act, irrespective of any observation made by the learned single judge in the improved order.
But what will happen to that award, your lordship, already passed by the
That
competent
is
authority?
passed, then that you have already questioned that.
I have not
This order is not going to affect those proceedings.
That your lordship may also observe, your lordship. In that event, your lordship, we are agreeable to that. As per the provision of the act.
That was on erroneous,
This intra-court appeal is filed by the appellant being agreed with the order dated 7/2/2022, whereby the learned single judge, while holding that the notice upon the respondent under section 3 of the Petroleum and Mineral Pipes Act, yes, right.
1962.
Under section 3 of the Petroleum and Mineral Pipeline Act 1962 was not served on, was not duly served on the given date, what was only served on 1/7/2020, and therefore
WPC number pending for
liberty was granted to the respondent to file objection within a period of 21 days with a further direction to the appellants to hear and decide the objection filed by the by the respondent as per section 5 of the Act of 1962. Full stop. It is informed by the concept of the parties that pursuant to the direction given by this court, the objections filed by the respondent pursuant to the notice under section 3 has already been dealt with and order has been passed. It is also informed that the land in question has also been acquired by the appellants. However, the issue regarding compensation payable to the respondent is pending consideration with the learned single judge in respect of a award before this court in a writ petition before the learned single judge pending consideration before this court in a writ petition in relation to the award passed by the respondents, passed by the appellants. Full stop. Taking into consideration the above facts and circumstances of the case, we are of the view that since the objections filed by the respondent has already been decided and the land has also been acquired, the issue regarding the payment of compensation, the award of compensation to the respondent, and the issue regarding award of compensation to the respondent is pending consideration before this court in a separate petition. Nothing nothing is required to be done in this appeal. And the same is disposed of with the observation that the issue regarding payment of compensation to the respondent will be governed by the provisions of the Act of 1962. Act of 1962. With these observations, this petition is disposed of. The writ appeal is disposed of.
Item 38 and 39.
Well, I am appearing in this item 39, my lord.
I am in 38.
Both against the, my lord, common judgment of the Honorable Single Judge, my lord. I was the writ petitioner before the Honorable Single Judge. And these appellants, my lord, they were, my lord, appointed, my lord, while the, my lord, rules, my lord, of 2003 was in force. And my lord, till then, my lord, the whatever rules were in force, my lord, there was no, my lord, provision for any promotion of the, my lord, grade 4 employee to the grade 3. So a writ petition was moved before this honorable court. And this honorable court, after hearing the parties, my lord, it was observed that a realistic, my lord, opportunity should be there at least once to every, my lord, employee in service career. And my lord, directed the state government, my lord, to amend the rules or, my lord, make some provision therein. Then, my lord, the 2018 rules, my lord, in, my lord, the supersession of the earlier 2003 rules, they have come up with the 2018 rules. They also, they have made no provision for, my lord, promotion. Rather, what they have made, my lord, a separate, my lord, direct recruitment from the grade 4 post, earmarking 5%, my lord, had been made, my lord.
That a memorandum.
Then, my lord, a memorandum has come, my lord, overturn all the, my lord, the provisions of the, my lord, rule. And the officer concerned, my lord, has said that instead of, my lord, promotion, it will be, my lord, instead of, my lord, direct recruitment, it will be by way of promotion, and the qualification will be, my lord, graduate for each of the, my lord, grade 4 employees, my lord. The earlier, this honorable court had, my lord, said, my lord, the realistic opportunity should be given. But prior to 2003, the minimum qualification required for the grade 4 post, initially it was, there was no, my lord, qualification. Then, my lord, it came, my lord, 8 standard. Then it came to, my lord, HSLC. Now, firstly, my lord, that, my lord, by notification, my lord, the authority can, my lord, supplement, but cannot supplant the provision of the rule, my lord. That is one of the ground I had taken, my lord. Because the rule does not visualize any promotion. Now, by the office memorandum,
So the writ petition is
writ petition has been allowed. Yes, allowed, my lord. But to the extent that that particular notification will remain suspended till, my lord, the rule is amended in that form, my lord. Necessary correction is made.
how you are aggrieved by that order?
My lord. My lord, this aspect, my lord, if they make a suitable, my lord, another office memorandum, without touching the, my lord, education qualification, because honorable single judge did not deal with the qualification part of the, my lord, grade 4 employees.
Still making of such provision, the Assam Secondary Education Service rule in respect of the promotional avenue to class 4 employee or promotion of the state of the junior as directed by the honorable court, common judgment dated so and so. unconnected, the state government education remain suspended and shall not be given effect.
Lordship.
This is what your, this is was your prayer.
Well, my prayer was having it found that this particular notification is illegal, expressly illegal. It ought to have been set aside, leaving no room because
If the learned single judge has kept it in abeyance, it's as good as
my apprehension
setting
only is
aside
that
of the-
if the education is not retained, taking a realistic approach. In that case, even if a promotion avenue is made,
But no, I think.
fail to understand how you are aggrieved, even though if it is not set aside, it is kept in abeyance. What's the problem?
because the honorable single judge, while passing the judgment, did not discuss as to the education part, of the education of the education qualification of the grade 4 employees. And by the impugn notification, it has been made that the minimum qualification will be graduation. So that part has not been touched. Only on the point of the power and authority, the honorable single judge has observed that this to be amended. If the authority now again amend the rule taking, because this honorable court did not interfere with the education part in the qualification part in the office memorandum. The state government may retain the same graduation as a minimum qualification for the grade 4 employees. So in that case, the particular
If the
judgment of
state government act in such manner, then you have a remedy to challenge that. Okay, you'll always be bad. That is, why you have challenged this order? By way of this appeal.
only to that that limited extent that the since the education qualification for the grade 4 employees that has been prescribed by the OM, having not been dealt by the honorable single judge while deciding the writ petition, and that office memorandum having only suspended.
And yes, Mr.
Lordship, we were not parties before the honorable single judge, Your Lordship. We were not made parties. Subsequently, when this order is passed, Your Lordship, what had happened pursuant to this office memorandum, Your Lordship,
That was in your favor.
it is in our favor. Pursuant to this office memorandum, files for promotion of the petitioners have been processed, Your Lordship. In the meanwhile, Your Lordship, this judgment from the honorable single judge came, Your Lordship, that process got halted, Your Lordship. And then, Your Lordship, since we are not parties to that proceeding, Your Lordship, we seek leave from this honorable court, and after getting leave, we prefer this appeal, Your Lordship. Our grievance is this, Your Lordship, against
The state government is having any proposal to amend the rules of 2018.
2018, there was another amendment brought in, but this part was not touched, my lord.
Why?
2023, there was some, in 2023, December, some amendments were brought on. But that was with regard to the teachers' qualification only, my lord. The LDA, that part, that promotion and appointment part has not been.
Division bench has already issued order.
My lord,
Why you are not complying?
this is, if lordship would have that rule which was introduced after 2003, my lord. The order of the division bench had come, my lord, on 11 September 2003.
Yes.
And my lord, the 2000, sorry,
September 2003.
and this to 11 September 2018. And these rules were notified on 18th of September, 7 days thereafter. Therefore, these rules did not contain it. Page 26 of the book, my lord, if lordship has.
Division bench order is there. Where is that?
In my petition, it is there, your lordship.
At page?
Page, your lordship will get it at page 91, your lordship. Page 91, your lordship. Operative part starts from page 102.
102.
102.
It ends at
Directions. Lordship will find that page 115. I'm sorry, 114.
113. 113, para 25, onwards, your lordship. The directions.
21. In service division, promotion usually means advancement in rank, grade or both. Promotion generally means appointment to a different post carrying a higher post or pay. From the provisional material or record is apparent that there is no provision for promotion of class 4 employee working in professional school, although instances have been brought on record to indicate some upgradation of the existing post. In the interest of justice, to mold the relief by the directing the respondents to consider framing suitable provision for promotion. The last para. Suitable provision promotion in the post of junior assistant prescribing such eligibility as may be deemed appropriate in addition to the filling of junior assistant by way of diagnosis within a period of 6 months. That 6 months have already.
But if lordship has the rules that were brought in 2018, the rules which were brought in, this was passed on 11th of September 2018. 18th of September, a week thereafter, these new rules were brought into force. Lordship has that rule, which is the bone of contention, it says 5% of the total post of junior assistant of a district shall be filled up by direct recruitment from the candidates amongst the grade 4 staff of the schools under the concerned district having requisite qualification with 5 years experience of continuous service as grade 4.
Which rule?
Lordship would have this book, page 26.
Rule?
This is rule 5.
Yes.
Rule 5(2), sub rule 2.
5% of the total
Graduation of a district shall be filled up by direct recruitment from the candidates among the grade 4 staff of schools under the concerned district having requisite qualification with 5 years experience of continuous services grade 4, and remaining posts shall be filled up by direct recruitment from the open competition. So here, my lord, we had got it that 5% would be only reserved for the grade 4 posts who would be participating. Now, if lordship has page 86 for a moment.
Direct recruitment expression should not have been issued.
That is what the office memorandum had brought in, saying that where we had in the rules it was written as direct recruitment, we will consider it to be promotion. That has been set aside by the learned single judge, saying that what the legislature used the term direct recruitment, and office memorandum will not substitute it by the word promotion, and therefore the office memorandum goes. Is the judgment of the learned single judge. Now, if lordship has page 86 for a moment, the eligibility qualification of a junior assistant, graduate from any recognized university. But that is my learned friend's grievance that they had entered service as as class 8. Later it was brought up to class to matriculation for a promotion to junior assistant. Now it is graduate. Since they are not graduate, they would never be able to participate in the selection process for junior assistants from the post of grade 4. That is their been, they should have challenged it.
That challenge has not been decided by the learned single judge.
Madam, that the qualification part could not have been decided, madam. It's part of a rule has to be decided by the division bench, madam. That was never challenged.
That rule was not set. That rule was prescription for qualification for the junior assistant. And for the promotion, there is no everything in that particular rule. And what the argument around the distribution of the has paragraph 54, your lordship may kindly see, my lord. Therefore, an employee should be given an opportunity of advancement and they must provide realistic opportunity to employee to move up by way of promotion. The institutions were appointed somewhere 89 at prior 2003 came into force. And in 97.
Why you are not amending the rules when
No, that
you have to rule 5 में amendment करना है, direct recruitment की जगह promotion लिखना है.
promotion. That is what we had informed, but by the time 23 rules were amended, that the amendment part was brought in, this
Yeah.
got overlooked, madam. We have proposed it, madam.
Now you have proposed this.
Yes, yes. That takes a procedure, madam. It has to go through the.
Lordship, so far as we are concerned, your lordship, our submission is that this rule, if we go through the provisions of the act as well as the office memorandum, this office memorandum is supplementing the rules, your lordship. It is,
That if they are going to amend the rule,
that's.
what remains there?
Then your lordships may keep the matter pending and take them.
And so
ask
far as
them to take
regarding
a
your
call.
concern is there, that this graduation part which they have qualified, then the rules are.
My lord will find this paragraph which before it has been brought in the earlier, but a realistic approach. Madam, those petitioners were prior to 2003 rule. At that time, there was no qualification. Initially, there was no qualification that age.
Yeah, but this is even if it is clear.
That has not been put to challenge.
Starting more than 20-30 years, expecting a graduation from it is as good as no opportunity for us.
The proper course for you to challenge that rules, the validity of the rule. If it is discriminatory, then you have to challenge that rule, sir.
I would find that education qualification that has been wanted out is for the junior assistant, the direct recruitment. There is no avenue for the promotion there. And the earlier on, it has been said that realistic opportunity should be given to the employees for at least one promotion.
That's why only if it is as per your contention that this is not the realistic approach, then challenge that rules, sir.
Yes, but once they come up with the amendment, then of course, if it is.
So
not
why
realistic,
this appeal now? Why you have filed this appeal now? We fail to understand why you have challenged this order of the learned single judge.
I have challenged argument I have made before the honorable speaker. This memorandum is without jurisdiction power.
That has been accepted.
That is accepted. Second is, as per the earlier judgment, my lord, this notification is not a realistic opportunity for the education because of the qualification that has been prescribed the graduation. And have it prescribed less than graduation or at least something else.
Also for the respondent state has submitted that though in the 2023 rules, no provision for promotion, no provision for appointment of the junior of the class 4 grade staff of junior assistant to the junior assistant by way of promotion is provided. However, the state government is contemplating to making suitable provision for promotion of the grade 4 employees, grade 4 staff to the post of junior assistant
By amending the.
by making appropriate amendment in the rule 5. Therefore, some time may be granted. List on as prayed by the learned government advocate, list on 4 weeks, list after 4 weeks.
Briefly obliged.
Item 41.
May I please your lordship, my lord? By filing this writ appeal, my lord, we have challenged.
Yes.
My lord, by filing this writ petition, my lord, we have challenged the, my lord, order of the honorable on a single judge. Or she will find at page 275. The only question involved in this case, my lord, in case of a joint writ petition, those who are having a identical, my lord, interest and common cause of action, challenging the common order, should they require to pay, my lord, individual court fee? There are two decision of my lord, coordinate decision bench. One says not required, other says required. Then matter was referred to full bench. And full bench ultimately, my lord, on examination of all relevant provision, Body High Court's rule, Court Fee Act, as well as the subsequent amendment of 1992, arrived at a conclusion that if the, my lord, interest is identical, there is no necessity to, my lord, pay any individual court fee. Writ petition is maintainable. And court says, my lord, fact of the case is that when we belong to a deputy commissioner establishment, and deputy commissioner establishment is defined under section 2 of the, my lord, Assam Ministerial Service, Assam Ministerial Service Rule, my lord, 1967. Deputy commissioner establishment is having various branches. Court says, my lord, once we are working in revenue branch, or my lord, other, my lord, Rulta, extra. Court said, my lord, the person who are working in various branches, these are nothing but separate establishment. But rule 2, my lord, 2 says, 67 Rulta. What the page? At page 104. 104 action 1. At page 105. At 2, my lord. May I please your lordship, my lord? Now, I refer to, my lord, section 2(4) of the district, my lord, establishment ministerial, the district, Assam Service District Establishment, my lord, Ministerial Act 1967, page 105. It was defined that deputy commissioner establishment is a single unit, having different branches. Therefore, my lord, if a person may work in a particular branch of the deputy commissioner establishment, that cannot be construed to be a separate establishment. Court says, since we belong to separate establishment, therefore, my lord, we cannot have the common interest. And law laid down by the full court is that, my lord, if the interest is a, my lord, identical interest, arising out of a, my lord, common order, having common grievance, then it is a case. CPC, order 1, rule 1. Dharma koi raha nahi. Dona. Ali page na. $274, $275, $275. এটাই তো $265, এটা মানে বড় পণ্ডিত করো। এইটা
So what is your, what grievance you have raised before the learned single judge?
My lord, learned single basic merit of the case is that, my lord, in terms of 2017 ROP rules, my lord, there is a provision under order, my lord, on Note 1, Rule 8, Roman 5, my lord, B. In that case, my lord, there is a provision that if a senior incumbent is promoted prior to cutoff date 1/4/2016, day on which 2017 ROP rule came into force, and junior incumbent, my lord, who got promotions subsequent to cutoff date with a better pay scale, then in order to bring a parity in the pay scale, my lord, this senior government incumbent who got promotion prior to cutoff date, they will get equal pay scale. And according to private response number 21, he was given the benefit. Then we made an representation. Our representation was considered, and we are given the equal pay scale. Then all on a sudden, my lord, after 3-4 years, they passed the impugn order revoking the order with a direction that, my lord, this order is cancelled with effect from 1/4/2016. That is the merit of the case. And court says, my lord, we cannot entertain this writ petition, joint writ petition, because of this reason. Number one, you belong to defense, my lord, establishment.
Mr. Purkar, petitioner numbers 1 to 25, all of them are aggrieved due to revocation of their, all of them.
All of them.
So why did the learned single judge make a distinction between petitioner number 1 and the?
Make a distinction on the basis of three different, my lord, reasons. Number one, court said we belong to different establishment. Notwithstanding the fact that all branches are part of the deputy commissioner establishment in terms of Rule 24 of Assam Ministerial Assam Ministerial District Establishment Service Rule 1967. We are governed by that particular rule. Secondly, court said there is a single affidavit. And thirdly, my lord, court said, my lord, cause of action is different cause of action. And Pascal. Thirdly, different cause of action and Pascal. Pay scale. So what is the question of, my lord, having different pay scale? We are given equivalent pay scale. Equal pay scale as prescribed under the ROP rules. Common pay scale. And cause of action is same. We are agreed by a common order. On the same facts.
We are from the respondent state.
My lord, on this technical point, otherwise my lord, we have nothing to say. But one thing, my lord, the learned single judge has observed that, my lord, all these petitioners, 25 in numbers, all are having different, my lord, pay scales. They want parity with respondent number 21, who according to them, though is junior and holding the same post, is getting a higher pay scale.
They are aggrieved by the revocation of that pay scale.
My lord.
Earlier pay scale granted to them.
Lordship.
On the ground that there was no approval of the finance department. This is what the case
Yes, my lord.
of all the petitioners.
All the petitioners. My lord.
Then how the cause of action is different?
Cause of action, my lord, yes. But honorable court said that, my lord, only since, my lord, only one court fee has been paid.
Court fees at the most.
Yes.
₹50,000.
They pay for individually paid of the.
Yes,
My lord was wrong in that.
My lord, that question was dealt with by full court. There are two defined judgments, and let me, my lord, explain. One decision.
Only one court fees is sufficient.
No. Yes, my lord, exactly. First court says, coordinate bench division bench says, you have to pay equal pay, my lord, individual court fee. Other court says, considering all the aspects of the matter, High Court's rule, then Court Fee Act, as well as the notification of 1992, says that if interest is the identical interest, you need not pay cost, my lord, any individual court. Therefore, we are covered by that decision of the full court. My lord, we have annexed that judgment. Therefore, my lord, whether we are at best, my lord. 278.
So it cannot be said that they have a separate cause of action. Municipal both fees come to that.
Yes, Rohit. You are all the respondents.
That is private respondent, respondent number 21.
21, who is respondent number 21?
21. We have taken step, no?
You are for the 21. What do you want to say?
I have no objection, Lordship.
You have no objection. Pass on. I'm going to pass on.
My lord,
Will pass on.
my lord. Obliged to you.
Item 42 and 43.
Fair division also. My lord, the present petitioner has challenged the appointment of respondent number 3.
The matter appears to be of single bench. Why it is listed before the division bench?
No, there is a notification of this honorable court, registry. It says, except service matters pertaining to staff of Guwahati High Court and subordinate courts, all other cases pertaining to principal seat of the Guwahati High Court in permanent benches in which Guwahati High Court is as party shall henceforth be placed before the division bench. So he is yet to become a staff, perhaps that is the reason. He is seeking appointment as driver. This will not, may I just hand over this notification?
In district court.
Yeah, in the. Yes, in the establishment of district and session judge at Kokrajhar. Because that is the reason why it has.
ये तो स्टाफ नहीं
Why you have implemented Guwahati High Court as party respondent?
Normally it is done. In earlier case, item 43, my lord, I did not make the Guwahati High Court as a party, but thereafter it was made party by the registry, my lord. That's why in the latter case, it is the latter case. The earlier case was 102, that is item 43, my lord. In that case, I did not make the Guwahati High Court as a party.
Yes.
Now, my lord, my case is this, my lord. The present petitioner applied for the post of driver under the establishment of district and session judge at Kokrajhar, my lord. Now, my lord, the present petitioner has 6 years experience as driver. And that is on record, my lord. For a moment, I draw your lordship kind attention. Kindly see page 19, my lord. This is to certify that Mr. Chandramohan Nath, son of so-and-so, resident of Tilapara, Bhodgaon, Kokrajhar, has been driving my own personal vehicle since 3/9/2012. Till date, without any driving complaint. I wish him success in his life. That is Mr. Jitu Mani Borman, Chief Judicial Magistrate. So, since my lord, 2012, and this certificate was issued in 2016. So in that view, I have almost 6 years of experience as driver.
These were 4 years.
2012
to 2016. 4 years experience. That is less than 4 years.
9, 10, 11, 12.
12,
No.
13, 14, 15,
No, lordship.
16, 16 पूरा हुआ ही नहीं है.
No, lordship, kindly come page 20 again. This is another certificate.
20.
Yes, 20. This is to certify that Sri Chandramohan Nath, son of so-and-so, has been known to me since my joining at Kokrajhar as Chief Judicial Magistrate in the month of March 2016. Since then, he has been serving as driver of my personal vehicle. He is sincere, efficient, hardworking, and is a man who keeps his trust. So, my lord, this is 16 to 18, 2 years. All total, nearly 6 years, man. I have experience.
Which
No.
car, personal vehicle, which car, which personal vehicle of?
Personal
model,
vehicle, assistant session judge.
state which vehicle he was having? Which car, which, if it's a car, it's a nano car or
My lord,
what was the car?
it is the certificate. I cannot go beyond that because
Beyond that,
it
then
is not mentioned.
which car he was driving?
But a car, we should understand that this is the car who is normally the magistrates use.
Normally, which car? Normally, in state of Guwahati, the magistrates use.
And normally, a magistrate does not keep only in one place. He goes here and there as well in his office also. So that car must be a flying car always. That is not a car which is stagnant. So my submission is this other
So you are having 6 years
and
experience.
6 years experience as driver. And my lord, in this case, the private respondent number 3 who has been selected and appointed, he has less than 2 years of experience.
So how it makes a difference, sir?
Difference, my lord, 6 years and less than 2 years.
Maybe a person having experience of many years of driving is not efficient driver as a person who is having 1 year experiences and is driving vehicle.
But there is, my lord, that may be presumption, but presumption is not the law when there is the.
So is there any provision under the rules that the person having more experience will is liable to be selected in comparison to the person having less experience?
But it's a matter of common sense, my lord, 6 years and 2 years.
In a court of law, common sense will not prevail, sir. In a court of law, if we are going to decide by common sense, then
Because,
where is the need of court?
Because, my lord,
It can be decided by two persons
My
sitting
lord,
together by
that
common
may be.
sense.
But both the officers say that he is sincere and without any complaint. So it means I have better.
Do you think this
And
certificate will
another
bear
thing,
any?
my lord, in this case, the respondent number 3 has not come. He has not filed any affidavit. And what I have said that I have better experience, I have better expectation. So he has not come.
So
Only,
if even though if suppose he appear before this court and say, no, I'm more experienced, then
no, that is
then
the,
we both of us will go and test the driving that yes, who is the.
no, my
driver.
prayer is, no, my lord, my prayer is this, lordship, the opinion of the expert. Opinion of the expert is good and very good. But what is the basis, my lord? What is the basis on the,
Assessment at that time, when at the
in
time of
oral marks,
interview-
my lord, both of us have got 28 marks.
Fine.
28 marks, an oral interview. But the expert has given that I am good and he is very good.
Very good.
Now, very good should be on the basis of known sources of law. When I have 6 years of experience,
Signal test, very good.
yes, and I am good.
Technical driving skill test. Motor vehicle inspector. Sir, this technical driving skill test was who was the person who took this or who
Another
conducted
thing,
this
my lord,
examination?
here some sort of question mark. Kindly see page 26, my lord.
Motor vehicle inspector.
Yes, MBA.
So the motor vehicle inspector has reported that in signal test he is very good.
Yes.
What's wrong in that?
No, that is,
Signal test is very important, sir.
no doubt he is an expert, but my prayer was that he is otherwise influenced. That is why
Otherwise,
influenced, my lord.
no, my lord. How?
I influenced because there are reasons. Kindly see, my lord, page 26.
Page 26.
6. I have sought two things. by RTI application. Number two, Lordship kindly see, marks given by each member that I have got, resolution taken by the selection committee. Now, Lordship has seen, what is the answer? Kindly see page 27 now.
Yes.
27 bottom. In respect of document number 2, the resolution dated 24/5/21, resolution dated so and so, 14/21, resolution dated so and so, and resolution dated so and so. No separate resolution seen for selection of the appointment for the post of driver in the file, though the note sheet is seen for issuance of the appointment letter for the purpose of driver. So, my lord, note sheet, there is the recommendation that appointment may be issued, but there is no resolution from the selection committee. So this is also a question mark. And third thing, another thing, my lord, just after issuing the appointment letter, next day, my lord, it is my information that learned session judge has been transferred.
Learned session judge
Has been transferred to another place.
on account of this.
No, not, I have no idea. Maybe it is routine transfer.
Transferred on account of some.
No, I am not saying that. I am not on that. My only prayer is that there was no so much urgency. Then he will issue appointment letter today and tomorrow he will go. There is no such urgency. So my submission is this, my lord. My lord, I am not seeking.
He was aware of this fact that he is going to be transferred tomorrow.
That idea I do not have.
Then what's the point in that?
No, as per there was the talk of the court that judge is going to be transferred tomorrow. So that talk was there.
The court, there are so many.
So my
talks in the
submission is
corridor.
this, my lord.
Every talks can't be taken.
My lord, my submission is this, my lord. Another expert may kindly be appointed.
Expert of.
The matter will be remanded to another expert, and then
The committee of the district judge and two other.
no resolution is there, my lord. No resolution of the committee is there. This is RTA application reply. Kindly see, there should be a district judge's court, my lord. This is not the court of ordinary office.
Try your luck somewhere else.
There is no resolution, my lord. There is no resolution. So my prayer is. Selection advertisement was issued. Advertisement itself contained provision that Viva Voce and skill test. In Viva Voce, both of them got equal marks, and skill test was conducted in the presence of the MBI, MBI, after doing the skill test, gave marks that the private respondent, he was very good in signal test, and the petitioner was good. It was not said that the petitioner was bad, but on comparison of merits, he found that the private respondent, he was more skillful. Then where is the wrong in the decision-making process, Law is absolutely settled, Read code doesn't normally go into tinkering the opinion of the expert committee.
What is the other matter? Item 43?
Item 43, my lord, Mr. Sumitra Sharma is appearing. In 43, my lord. MS Sumitra Sharma. Perhaps this is with regard to Chokidar appointment. My lord, I am not in this matter, my lord. It is
connected with this.
By the way, it is, my lord, perhaps, in my humble opinion, it is better case. Because in the written test, there was lesser marks.
First one is bad case. We close it.
Not bad case, better. I say, there was a good case, it is better case. That is my humble understanding, madam. Now, lordship, here, written marks were given less than the oral interview. So there is a settled position of, settled I may not say, because law is coming every day in a different dimensions. Now, lordship would see here, there was only 10 marks in written test. But in the oral test, my lord, connected no one. Both these matters are different. It is Chokidar, that is driver. Earlier one is driver.
Election in other matter also?
Yes. 43 also.
This item number.
42 is a driver matter.
And 43 you are
43 is Chokidar matter, but my matter. Both are my matters.
Both counsel. You are the counsel for that.
Yes.
And who is for the this High Court?
My lord, so far as 42 is concerned, I am appearing. 43, MS Sumitra Sharma, she is appearing. She is a high, but I have asked my colleague to call her, my lord. She is coming. But issues are different, my lord, and selection also different, my lord.
My lord, in 43, there were 10
Everything
marks.
is different, except that the synopsis is cut and paste, same in both the cases.
Chokidar. Second one is Chokidar. First one is for driver. My lord, here's a serious question. Whether oral marks can be more than the written marks. Here, written marks are only 10, my lord. And oral marks has no limit, my lord. In this manner, the interview has been conducted. So I will show that, and this Honorable Supreme Court has also said in this matter, my lord. I have brought
Out of these two cases, which case is better?
my lord, both the cases are good, but I think 43 is better than 42. That is my humble understanding. Subject to your lordship's
43
approval.
admit,
My lord.
43 admit, if it's better, admit. No need to issue notices, parties are already represented. 42 will dictate the order.
But if 42 is not a bad case, sir.
But better case
No,
is
no, my lord.
admitted.
My
and
lord,
better
law is,
case will
law,
consider it.
my lord, let me satisfy your lordship.
Yes.
Law, the court should not only deliver the order, it should appear that something is done. When a person will
Indeed,
take
will
6
deliver
years
the order, then
experience,
appear will not dismiss this petition simply saying dismissed. Will deliver an order. No doubt about that. Will
in
deliver
that
the
case,
order.
my lord, my limited prayer, mainly prayer is that better maybe can be remanded to fix, to select another expert. And on the basis of that, because there are so many question marks, no resolution is there, my lord.
We'll consider.
Very serious matter, my lord. There is a committee, but there is no resolution.
We'll
So all
read-
this raises question marks.
We'll read and go through the whole petition as well as the reply, and then we'll pass an order, appropriate order.
Right.
Well, so far as item 43 is concerned, my lord, SC GAC has not been shown, I am told.
SC?
SC GHC in the cause list, but that is the reason my friend, she missed the item, my lord. Item 43. So
Who is the standing counsel for Guwahati High Court?
in that matter, Sumitra Sharma, MS Sumitra Sharma.
So same parties are already represented. This matter for final hearing in due course while showing name of Mr. Sumitra Sharma, standing counsel for High Court.
Yes.
Miss Sumitra Sharma.
Yes. Fine.
Objection.
Deeply.
Yes.
43 admitted, 42 dismissed.
Passed over matter 26.
Bad please, your lordship. My lord, this intra-court appeal has been filed against the judgment and order dated, my lord, 11/1/2024, whereby my writ petition was dismissed, my lord.
My lord, before my learned senior start, my lord, no copy has been served to us. We are appearing for the fishery department, my lord.
That for government it was served. my lord.
Government is different. Deputy Commissioner Sakla Jabas, Fishery Department.
Supply copy of.
My lord, then, my lord, it is may come for admission on day after tomorrow, my lord. Some urgency is there, my lord,
Agency is there.
my lord.
Day after tomorrow.
Lordship.
I'll submit a copy, my lord.
Copy of the writ appeal along with the requisite documents be supplied to the consent for the
Fishery.
fishery department. List this matter. Monday को कर लेते हैं. Monday.
Monday.
Lordship, SC Fishery may be reflected in the cause list.
While showing name of MS so and so in the cause list.
Deeply obliged, Lordship.
Supplementary list, item 47 for admission.
May it please your lordship. My lord, this Sumoto PIL which is with regard to, my lord, maintaining basic amenities in the religious places
Yes.
in the state. My lord, there was a direction by this honorable court to file affidavit to the, by the deputy commissioners of each district. As of now, 11 districts are yet to file their affidavit. Other districts, my senior friend has filed. 11 districts are yet to file their status.
11 districts of state of Arunachal.
No, Assam, my lord. This is only.
No, we have already filed 20. And today we are filing today, 22 and two districts, we have received information that there's no major religious places. It out already 26 we have completed, now 7 left, no, 5 or 6 left, madam.
In respect of remaining districts,
Yes.
you are going to file, you are filing this affidavit.
My lord, after 2 weeks, Lord.
Because this is going on quite for a long time. If my friend
No,
completes it,
almost-
then I'll compile everything and I can place here before the lordship in a
And
tabular
the
format.
Government advocate. Please.
RT border.
RT Bora last में Endas who, Mr. RT Bora. Learned additional senior advocate, government advocate. Please. 3 weeks time to file affidavit in respect of the remaining districts. Full stop, time paid for is granted. This matter after 4 weeks. In the meantime, the affidavits filed by Mr. Bora on behalf of, for the remaining districts. The copies of the affidavits filed on behalf of Mr. Bora in respect of remaining district be supplied to consent for the petitioner in advance.
Yes, I am deeply obliged.
Deeply. obliged.
Daily list for hearing, item 45 and 46.
May it please your lordship.
Yes.
Lordship, I'll pray for some accommodation today on account of my seniors.
I have no objection, but our part can be heard. Because this case has been under fire for a long time. And in fact, we have taken a very preliminary ground that a association has no rights to challenge the reservation matter. But it goes against Supreme Court judgment of 1967. They are class.
When?
I leave it to your lordship's convenience on the first week of March or thereafter, your lordship, except for 4, 5, and 6. Except for 4th, 5th, and 6th, subject to your lordship's convenience.
Can it be on 5th?
Yeah, the 4th, 5th, and
Just
6th.
in the 3rd week of March, we'll pick the date. 3rd week of March.
I'm good.